Welcome, everybody, as we start heading into the room. Welcome to this Zoom presentation, an overview of the Massachusetts Parentage Act. We're going to give you a few minutes for people to trickle into the Zoom room, get themselves situated, get yourself a little water, your salad, whatever you want. It's a beautiful New England day here in Massachusetts. We're happy to have you. I'm going to start, we're going to start the presentation at 12:31. And for those of you, just to be aware, we are recording this presentation, and we will have it available afterwards. Okay. I'm going to get started. I want to welcome every one of you to what we see as a really exciting moment for Massachusetts of looking forward ahead to the enactment date that is coming up for the Massachusetts Parentage Act. It will be in full effect on January 1 of 2025, and we're here to provide an overview of the act. This is a 1-hour lunch session to give you a high-level sneak peek into what the act does. We will share other educational events that go into more depth about various provisions at the end of this presentation. But we're grateful to have you here with us today. And I want to send my best wishes to everyone on behalf of GLAD, the organization that co-led the Massachusetts Parentage Act Coalition, and All Paths Family Building, and Kate Weldon LeBlanc. She's not able to be with us today, but she sends her regards, and we're grateful for All Paths' work leading this coalition. We have phenomenal panelists today, and I'll just briefly give you an overview of the agenda. I will be talking a little bit about kind of the overview, the why of the Massachusetts Parentage Act, and some of the kind of some of the amendments to Chapter 209C to bring it up to best practice and the 21st century. Then we'll welcome Professor Doug Niejame from Yale Law School to talk about the de facto parent protections and the competing claims provision. Then Kath Capelli, a practitioner from Newton, will talk about the assisted reproduction protections. And then Bruce Hale from Newton as well will talk about the surrogacy protections. And then we will leave time for questions if folks have questions, and we will share some resources that we have available on our website, as well as further educational events about the Act. So with no further ado, I will ask my GLAD colleagues. Thank you so much to the GLAD public education staff for assisting with this webinar today to share the slide deck. All righty, next slide. Before we start, I always like to start remembering the families that were at the heart of the work to pass this law. These are just a few of them. I'm grateful for the families who told their stories year after year and led to the passage of this act. Also grateful to our lead sponsors. This is a fully bipartisan bill, and we're grateful to Senator Sear and Senator Tarr, and also to Representative Peake and Representative Kane, who really led this effort and really successful effort. You'll see here some pictures of the ceremonial signing with Governor Healy, which was really a phenomenal event. And I think particularly in this national context, when there's so many attacks on LGBTQ people, so many efforts to kind of bring us back in terms of, decisions about our most important aspects of our lives, it's really thrilling to see Massachusetts take a step forward, and particularly join the rest of New England. Next slide. I also want to thank the over 70 organizations that made up the Massachusetts Parentage Act Coalition. You will see their logos here. We had so much collaboration and support at every step of the way, from children's organizations to LGBTQ organizations to reproductive organizations to hospitals, to lawyers, to social workers and beyond. It was a phenomenal group, and we're really grateful to every organization who played a role. Next slide. Okay, and I just want to introduce myself. My name is Polly Crozier. My pronouns are she and her. I'm the Director of Family Advocacy at GLBTQ Legal Advocates and Defenders. And prior to that, I was a family lawyer with my own practice along with Joyce Kaufman in Cambridge, Massachusetts. And I also served as a law clerk for the Probate and Family Court in Massachusetts. So I have really done a lot of litigation in the trial courts and the appellate courts in Massachusetts and saw firsthand the vulnerabilities for so many families that weren't protected in our statutes, particularly children of LGBTQ families. And at GLAD, I've really had the tremendous pleasure to work on reforming and bringing equality to laws throughout New England, in Michigan, in Minnesota, in the area of parentage equality, which we will talk about today, and also expanding access to adoption and expanding access to fertility healthcare, among other things. So that's a little bit about me. My contact information is going to be on the last slide. Feel free to reach out for questions or technical assistance on the cases or issues you're dealing with. Next slide. I want to also just give a little bit of a snapshot because many family lawyers don't practice at the intersection of parentage, which our panelists here today really do. To just say, parentage is that legal relationship between a parent and a child. It is so incredibly important for the stability and well-being of a child across their lifetime because it is the source of so many rights and benefits for children. You will see some of those listed on this screen. It is really an important source of stability for children. Next slide. I also want to share the pathways to parentage for those, and perhaps a visual sometimes helps, because our goal was really to make sure that every child in Massachusetts has a legal path to protection, no matter how they come into our families. And here are the pathways that we have in our law now, and that we hope that every state has throughout the country, because we don't want to leave a child unprotected. And unfortunately, before this act, Massachusetts parentage law hadn't been updated in over 40 years and had tremendous holes in protections for children born through assisted reproduction, children of de facto parents, children born through surrogacy, and also our law was simply outdated and had outdated language. Next slide. Here were some of the goals for the Massachusetts Parentage Act. I will just share, first and foremost was equality for all children. We wanted to make sure our statutes had guidance for the courts to make sure that every child could establish their parent-child relationship. And again, the effective date is January 1st of 2025. And before we kind of head into the meat of the statute, I want to say one thing that does not change as a result of the Massachusetts Parentage Act. Nothing changes about custody, visitation, parenting time, or child support. So those fundamental pieces don't change. This law is really about who is a parent to a child and how do you establish parentage. Next slide. Okay, so let's head into the heart of the bill. I will be providing an overview of some of the changes to the first part of Chapter 209C. You will see from the bill, the law, which there's a link on the last slide to the chapter law, so that you can see it yourself. About the first 64 sections are essentially updating Chapter 209C so that we have updated inclusive, gender equal and non-offensive language, right? We are no longer talking about out of wedlock children, for example. We are talking about non-marital children. We have a new title to Chapter 209C, non-marital children and parentage of children. So 209C now deals with non-marital children, which is kind of the paternity laws we all know very well, and then parentage of children, which is a number of new provisions. The updates, the MPA brings a wonderful non-discrimination language to Chapter 209C to make clear we're not going to discriminate in parentage based on, in particular for my organization, sexual orientation, gender identity, gender. The updates also include some really helpful definitions to make sure that courts and families and practitioners are all on the same page, right? And Kath will talk a little bit more about some of the key definitions, particularly because they relate to children born through assisted reproduction. And then just generally, there's updated language. We are moving towards parent instead of mother, father, parentage instead of paternity, language that makes it clear that our law includes the full diversity of families in the Commonwealth. Next slide. Thank you so much. And I will also say one of the definitions, the definition of parent, lays out those different paths to parentage that we talked about on the earlier slide, right? For example, saying if you give birth to a child, unless you're a person acting as a surrogate, you are that child's parent. Nowhere before in Massachusetts law was that actually spelled out. I want to highlight an important change to Chapter 209C, Section 6, right? Just because this is a really important section for people who are working on parentage establishment. This is the presumption section. And I love this change, and first and foremost, because it really makes clear in the statute that this applies regardless of gender. So it now says a person is presumed to be the parent of a child and shall be joined as a party if I've pulled out kind of the two key ones. If a child is born into a marriage, or if a child, if someone has jointly with another person, with a person who gave birth to the child, received a child into their home and openly held the child out as their own. So this isn't a substantive change, but it's very important, and particularly given the Partnin case, the JM case, it's really great to see this codified in the statutes. Next slide. I also want to flag another exciting provision of the MPA, which is expanded access to voluntary acknowledgements of parentage. A VAP is a simple civil form that parents can sign in the hospital or beyond to voluntarily establish parentage. It has previously been generally available only to genetic mothers and fathers, and the Massachusetts Parentage Act codifies that there is clear expanded access to this form for children born through assisted reproduction and for presumed parents. Now, why this is important is because so many families, particularly in the LGBTQ community, face tremendous discrimination and worry about the security of their relationship. And a VAP is the equivalent of a court decree of parentage, and it should get full faith and credit in every state. So if LGBTQ families can sign a VAP to establish their parentage at birth, they are much more secure. It's an exciting development. And we actually are the 12th state to have expanded access. So now I'm going to turn it over to our other panelists, because now we're going to move through from the kind of amendments to Chapter 209C to bring it to the 21st century into the new substantive provisions of 209C. So I will turn it over to Doug.
Great, thank you, Polly. Next slide, please. And we can move to the next slide. I'm going to talk about de facto parentage in the MPA and the completing claims provision. So de facto parent doctrines are one of many functional parent doctrines, which are doctrines that treat someone as a parent when they have developed a parent-child relationship and parented the child. And there are about 2/3 of states around the country that have some sort of functional parent doctrine. And these doctrines vary in their legal consequences. So some of them yield standing to seek custody on a best interest standard. Some of them yield legal parentage. Some of them yield only standing to seek visitation under a best interest standard. But my colleague, Courtney Jocelyn, and I have done work looking at all of the electronically available functional parent cases from around the country. And what we find overwhelmingly is that the person claiming functional parent status in these cases has been the child's primary caregiver. And so what these doctrines really do is that they secure the child's placement with the person who has been consistently providing them with the parental care that is essential to children's healthy development. And so these are really child-centered, child-protective, and family-preserving doctrines. In fact, we also find that a large share of the cases, about 1/3 of the cases, tend to involve some child welfare involvement. And the ability to claim functional parent status is essential in many cases for warding off additional state intervention and allowing the child to stay in their home with the person who is parenting them. The de facto parent provision in Massachusetts is, in my view, one of the most important provisions in the Massachusetts Parentage Act. Next slide, please. Massachusetts has had a de facto parent doctrine for many years. In fact, it was one of the first states to have its state high court adopt an equitable de facto parent doctrine explicitly. But that doctrine only provided for standing to seek visitation. And in that respect, Massachusetts quickly became an outlier around the country. Practically all other functional parent doctrines, whether they're called de facto parent or in loco parentis or psychological parent, provide greater rights and responsibilities to the functional parent than the Massachusetts doctrine that existed through the courts. And so what the Massachusetts Parentage Act does is it, in important ways, codifies existing law in Massachusetts by recognizing the status of de facto parent. But it also importantly expands that status by treating the person who is a de facto parent as a legal parent. Now, the requirements of the code are more onerous because it is leading to this status of legal parentage. And so we're going to talk about those requirements. Next slide, please. Because de facto parentage is meant to be child-centered and preserve the child's relationship with the person parenting them, it requires that both the de facto parent and the child be alive in order for an action to be brought, and also that the child be under 18. So that is unlike other parentage provisions. We also have in the de facto parent provisions of the Massachusetts Parentage Act some additional hurdles that you won't see in other parentage provisions. So, for instance, the person claiming de facto parent status must file a verified complaint alleging specific facts to support each element that's required to establish de facto parentage. There are 7 elements. The court is instructed within 60 days of the filing of that petition to determine whether the plaintiff has standing under the de facto parent statute. In other words, has the plaintiff alleged sufficient facts to make out the 7-factor test? And if the plaintiff moves beyond this standing threshold inquiry, the plaintiff eventually needs to show that by clear and convincing evidence, again, something distinctive, by clear and convincing evidence that they satisfy the 7 requirements for de facto parent status. So we can go to the next slide and I'll start to work through those 7 requirements. So first, the person must show that they resided with the child as a regular member of the child's household. And then we have a particular time requirement for not less than 3 years or 40% of the child's life, whichever is shorter. That means, for example, a 4-year-old, in order to claim de facto parent status, the plaintiff would ordinarily need to show that they lived with the child for 3 years, because 40% would be only about 1.5 years, and not less than 2 years is accepted under this provision. With a 5-year-old, you would have 3 years or 40% being 2 years, so you would be able to use the 40% to show 2 years. Not until a child is 7.5 does the 3 years actually equal 40% of the child's life. This all, I know, probably seems quite technical, but it means that you need to be very careful about what the required time is with respect to the age of the child. But you should also note that there's a provision here that allows a court to accept a shorter period of time in extraordinary circumstances. And so if you have that 4-year-old child and the person hasn't been living with them for 3 years, but has been living with them for 2.5 years, they may be able to accept that shorter period of time. Or you have a 2-year-old child and they've been living with them for 22 months, they may be able to accept that shorter period of time in extraordinary circumstances. So that's the first prong. The second prong, the plaintiff has to show that they engaged in consistent caregiving of the child. And this includes shaping the child's daily routine, addressing the child's developmental needs, and providing for the child's education, medical care, either on their own or in a co-parenting arrangement with another parent of the child. Next slide, please. The third requirement, the plaintiff must show that they undertook full and permanent responsibilities of a parent without expectation or payment of financial compensation. So you can think of this as the provision that's essentially excluding paid childcare providers from being able to make any claim to parentage. The fourth requirement is that the plaintiff held out the child as the plaintiff's child. This is different than what you might see in an equitable de facto parent doctrine, and it's different than what many doctrines around the country look like. This is going to limit the number of people who can claim functional parent status, and that's important to recognize. But it also means that you're really capturing people who have formed a parent-child relationship, and the child and the person understand themselves as in that parent-child relationship. And so there's a showing that the person has actually been holding out the child to others as their child. Fifth, the plaintiff established a bonded and dependent relationship with the child that's parental in nature. In other words, there is a parent-child relationship between this plaintiff and this child. The child is bonded to the plaintiff de facto parent. Next slide, please. Sixth, this is a really important provision and one that also can be a bit confusing. You must show that each parent of the child consented to that parent-child relationship being formed between the de facto parent and the child. If a child has only one parent, then it's just that parent consented. But if a child already has two existing legal parents, then this requires that the plaintiff show that both parents consented. What does consent look like? Well, consent includes a showing that over a period of not less than 6 months, they held out the plaintiff as a parent of the child. So not only did the de facto parent hold out as a parent of the child, but the other parent held the person out as a parent of a child. They engaged in shared decision-making with the de facto parent. This is going to be shown in many circumstances in which the de facto parent has been co-parenting with another parent of the child. But there are also many circumstances, and from the research that Courtney and I have done, this is actually quite typical, in which another parent actually has not been an involved parent in the child's life. And in those situations, it would be impossible to show that the person held out the de facto parent as a parent, or that they were co-parenting and engaged in shared decision-making, because that other parent just hasn't been parenting the child. And so the statute here allows a court to determine that a parent has impliedly consented to the de facto parent's parent-child relationship. So if a parent has not been involved in the child's life, then they might be seen to have impliedly consented to the person forming a parent-child relationship. And that, the statute provides, requires a showing that the person hasn't meaningfully engaged with the child through direct contact, decision-making, or regular financial support for a period of 2 years. So this isn't something that necessarily rises to the level of abandonment. And so that abandonment would not be a sufficient way to deal with this. Instead, it's someone who's not a consistent parent in the child's life. And then finally, adjudicating the plaintiff to be the child's parent is in the best interest of the child. If a person, by clear and convincing evidence, satisfies these requirements, then the person is to be adjudicated a legal parent of the child, unless there are already two existing legal parents, and then we would look to another provision. That's the competing claims provision. Next slide, please, which is going to apply in these situations, but also in many other situations. So yes, there's case law in Massachusetts on competing claims in situations where the father, biological father of a child born to a married woman is not the child's husband. But it is important to have statutory directives to deal with these situations and others that also involve competing claims. So, of course, the paradigm situation is married woman gives birth to a child. Her husband is presumed to be the legal parent of that child, but there is another man who is the biological father of the child. And now you might have competing claims by those two men. There are other situations in which you also might have competing claims. The statute now instructs courts to adjudicate competing claims through a best interest of the child standard. And it provides various factors that the court is instructed to consider. So, for instance, the court should consider the age of the child, the length of time during which each person was a parent to the child, the nature of the relationship between the child and each person, the harm to the child if the relationship isn't recognized, each person's basis for parentage, and any other equitable factors arising from the disruption of the relationship between the child and the person. On this view, the court can choose who among the two competing claims should be recognized as the legal parent of the child. But importantly, this provision also allows a court to find that a child has more than two legal parents, if doing so is in the best interest of the child. And so in the de facto parent situation, if someone satisfies by clear and convincing evidence all 7 requirements, and there's 2 existing legal parents of the child, a court would find, if they are to adjudicate that de facto parent a legal parent, that it is in the best interest of the child to adjudicate the person a third parent. And that can happen in other situations as well. Okay, I will stop there and turn it over to Kat.
Thanks very much. I'm really grateful to be here today with such amazing colleagues. My name is Kath Capelli. I have a family formation and gender affirmation practice in Newton. I work a lot with LGBT families, and certainly within those families, parents and children who are going to benefit from the MPA. The MPA is going to really revolutionize how we secure parenting rights for all of our Massachusetts families. And my portion today is with regard to family formation using donated sperm, whether that is from a known donor, a friend or a relative, or purchased through a cryobank. For so long, and Polly certainly highlighted this, we've had to cobble together case law to protect families that were falling outside of protections and were not previously protected by a statute. That included same-sex married couples, opposite-sex unmarried couples, single parents by choice who use assisted reproduction, and multi-parent families, 3 or more. Next slide, if you would, please. So the path to parentage for all children born with assisted reproduction, as Polly mentioned, 209A brought in a whole new section, Section 1A, and it sets forth a number of terrific definitions and really clarifies who these people are and what their role is to be with respect to any child born through assisted reproduction. They start by, in Section 1A, defining what assisted reproduction is, and it clarifies it applies to all children born from assisted reproduction, which means not bisexual intercourse, and it clearly details the multiple methods of assisted reproduction. 46(4)B has actually been repealed, which was artificial insemination, and it applies to all forms of assisted reproduction, including artificial insemination, but also intrauterine insemination, donation of gametes and embryos, IVF, and transfer of embryos. And then it also defines and clarifies who is a donor and what is the donor's status. And that is a person who provides a gamete or an embryo that's intended for use in assisted reproduction, whether or not that's with consideration. A donor specifically does not include a person who consents to assisted reproduction with the intent to be a parent of a resulting child. So for instance, if there are 2 women and one woman is consenting to be inseminated, she's not a donor in that situation, she's going to be an intended parent. A donor shall not be a parent of a child conceived in an assisted reproduction based solely on a donor's genetic connection to a child. A donor cannot establish parentage by signing a VAP, and a donor is not entitled to notice to a parentage action under the MPA. So that's codifying adoption of a minor, the case back from 2015. What the 209, the MPA also does is certainly clarifies who is actually an intended parent in this scenario. A person, whether married or unmarried, who manifests an intent to be legally bound to as a parent of a child that's the result of the assisted reproduction. Next slide, please. So in under the Massachusetts Parentage Act, who may and may not initiate is important, a parentage action. First, we look to consent. In section 27D, a person who consents to assisted reproduction with the intent to be a parent is a parent of the child conceived via assisted reproduction and shall be a parent of that child. For marital and non-marital children via assisted reproduction, consent can actually be established 3 different ways. A record signed by the person giving birth together with the intended parent before, on, or after the child's birth. And consent may also be established even if it's not in writing. And those circumstances include when the parties agree to be parents of a child prior to the conception or the birth, with the court so finding by a preponderance of the evidence, or a person who seeks to be the child's parent together with the person giving birth and both voluntarily participate in and consent to the assisted reproduction resulting in the child's conception. So that's a lot about the planning and the participating and perhaps the purchasing of the sperm and going through all of the medical procedures leading up to. And those decisions are decisions that a court is going to look to by a preponderance of the evidence when we're establishing consent. Now, there's a carve out there with respect to consent if a person gave birth. If the person giving birth is actually married at the time, but you can check into section 27 for that carve out. Also, we're still on the prior slide, but with respect to genetic testing in section 27, section 27 applies to marital and non-marital children that were conceived with assisted reproduction, but the section doesn't apply to children conceived via sexual intercourse or assisted reproduction under a surrogacy agreement. Bruce is going to get into that piece, but genetic testing cannot and shall not be used to challenge parentage or establish a donor as the parent. Now we can go to the next slide. All right, so for initiating a mass parentage action, where are we going to do this, when, how, and what kind of relief can actually be sought now under the MPA as of January 1? Well, first, venue. Venue is broad under section 27B. It's the county where the child resides, was born, or is reasonably expected to be born. Children don't always end up being born exactly where they're supposed to be. And where any parent or intended parent resides, and also where an estate administration proceeding has started for a person who is or may be the parent. One important provision or important provisions for privacy under the MPA include sections 13 and 27K. At the request of a party, the court shall close the proceedings, and it refers back to section 13 to govern access to and segregation of these records. This court action, the docket, the pleadings, and all of the materials. Now, with respect to procuring a parentage judgment, Section 27J, the intended parent or the person who gave birth may start a parentage action under the MPA, and they may do so prior to or after the birth of the child. And when they're seeking the judgment, the relief they're seeking, they're actually requesting that a declaration of parentage that orders the rights and responsibilities to vest immediately at birth, exclusively with the intended parents or intended parent. And that's critical, as Polly had pointed out at the beginning, when those rights vest is really critical at birth for medical decision-making, for insurance, for all of those benefits. It's really important. In the seeking of the parentage judgment, the parents seeking it are also designated the content of the child's birth certificate from that point. And that's important so that the birth certificate is accurate and so that our Department of Public Health has accurate information as soon as possible. And all of these things under establishing parentage and seeking a parentage judgment, as folks have mentioned, the burden of proof under the MPA is a finding by a preponderance of the evidence. And I will turn it over to Bruce.
Great, thank you. Thanks everyone for being here. Thanks for having me as part of this presentation. Really, I'm very excited about the changes that the MPA, the Mass Parentage Act, brings to how surrogacy is practiced here in Massachusetts. This is the area that I've been focusing on since, I guess, 2015, when Polly and I sat down in our office to try to figure things out and start drafting some provisions here. The overall theme to the surrogacy section is that I want to share with you here today is that we've updated our parentage law to allow for the parentage of the child born through surrogacy to match the intent of the parties that are involved in the surrogacy process. And what we are recognizing here under the MPA is a mechanism to record the intent of the parties, and that is a surrogacy agreement. So let's go to the next slide. I have a couple of important definitions that we have in the MPA. We recognize two categories of surrogacy in the MPA, which is really important, and it's a slight change from our case law, our established case law here. The two categories, the definitions are right here. We have gestational surrogacy and genetic surrogacy. The key difference between these two categories of surrogacy is that in gestational surrogacy, the surrogate has no direct genetic connection to the child, whereas in the genetic surrogacy, which you may have heard of referred to in the past as traditional surrogacy, that's a term that exists in existing case law. But in genetic surrogacy, the surrogate also contributes a gamete for the conception of the child. Medically speaking, gestational surrogacy, the pregnancy conceived in a gestational surrogacy is always conceived via IVF and embryo transfer. A genetic surrogacy, however, can be conceived by IVF or it can be conceived via IUI, or intrauterine insemination. From a legal perspective, it's important to make the distinction between these two categories of surrogacy based on something that Polly talked about early on in this presentation, the presumptions of parentage that are held by the surrogate and that need to be navigated through in favor of the intended parents. The gestational surrogate will have the presumption of parentage based on delivery of the child, based on birth of the child. The genetic surrogate will also have that presumption, but that surrogate will also have a presumption of parentage based on genetics. And so we need to deal with that and accommodate for those under the law. Let's go to the next slide. Prior to the MPA, the judges in each probate and family court in each county across the Commonwealth have had broad discretion to determine the parentage of a child born through surrogacy. Parentage determinations have been fact-specific matters, and the challenge with that is that the facts in a particular case may not always line up neatly with prior decisions by our higher courts across the Commonwealth and our Supreme Judicial Court. So applying new facts to existing case law has been a bit problematic in some cases. We've relied on the equity jurisdiction of the court so that the judge can make their best determination based on the facts in front of them. This has been useful, a broad discretion of power to the courts. It's been useful while the practice of surrogacy has evolved over time. Ultimately, however, it's been inadequate because it leads to uncertainty and unpredictability for the families involved in these surrogacy processes. So it's good that the courts and the judges will now have guidance specifically given to them by the Mass Parentage Act of how to navigate through these cases. Let's go to the next slide. So some specific changes that we are now going to be seeing under our law. We have the surrogacy agreements expressly permitted. Those have been assumed to be permitted based on case law, but now they're expressly permitted so that the intent of the parties for the parentage, the intent that they have at the outset of the surrogacy process can be documented, can be validated, and the parentage then can be adjudicated as expected and as desired by the parties. We do have some baseline requirements for the parties and for the content of the surrogacy agreements themselves, some of which are here on the slide. These are not overly burdensome restrictions on the parties or on the process. Most of these are simple best practices for surrogacy today. Some of these will also mirror medical guidelines for the practice of surrogacy. Things like the surrogate, or all parties need to be at least 21 years of age. Certain evaluations need to be performed. And importantly, the surrogate needs to have given birth at least once prior. Let's go to the next slide. So with the valid record of the party's intent, the parentage of the child born through surrogacy will match that intent under the Mass Parentage Act. One key difference between the genetic and gestational surrogacy processes is that the genetic surrogacy agreement needs to be approved by the court prior to the conception of the pregnancy, while that's not necessary for gestational surrogacy. In both cases, however, the intended parents will be recognized as the parents of the child upon birth. The surrogate, very importantly, is not held to be the parent of the child. She will not have that burden of parental responsibility against her wishes. The court does have a deadline in the MPA, a deadline of 60 days to give a parentage order once proceedings have been commenced. Many courts across the Commonwealth today are able to process parentage for a child born through surrogacy within a matter of weeks. So it's shouldn't be too burdensome, but this has not always been the case. There have been some courts and some judges that have taken longer to decide these matters. And in a time-sensitive matter such as a pregnancy, this time frame in the MPA helps to give additional protection for these families. So I'm very excited about January 1 and these protections that are coming for people engaged in surrogacy. I'll turn it back over to you, Polly.
Thank you so much, Bruce, and Kath and Doug. Really appreciated those overviews. I wanted to share now before we head into Q&A, so gather questions if you have them. I wanted to share some additional educational opportunities that are coming up. On November 14th at 7 p.m. at night, we're going to host a webinar specifically for families, parents, prospective parents, community members, the non-lawyer audience, to learn about the MPA and what it might mean for their family. You can register for that, or your clients can register for that on GLAAD's website. And then on December 9th, we will be having a 2-hour more in-depth training on the various provisions of the Massachusetts Parentage Act through MCLE. And the registration link for that is coming soon. If you are part of a group, a bar association who would like some members of the coalition to come and talk to you about the law, please feel free to contact me and we can set that up. Next slide. I also want to walk you through some resources that we have available. We will share the slide deck for registrants afterwards, but I want to share that all of the state forms and information about voluntary acknowledgments of parentage is available on GLAAD's website. You can access the current Massachusetts form, and we will have the updated form there ready to launch by the January 1st date. We also have an informational tool about the paths to parentage to better understand that. And you'll see the link to that, as well as a FAQ about the Massachusetts Parentage Act that might be helpful for you or your clients. The Massachusetts Parentage Act Coalition website remains available at massparentage.org. And I wanted to share also Professor Nijam and Professor Jocelyn's wonderful research about de facto parentage and functional parentage is also available through the Columbia Law Review, and I have included the link here. Next slide. Finally, I will share, here's our contact information. You're welcome to reach out with questions or again, with requests for training or education. And also to say that GLAAD, GLBTQ Legal Advocates and Defenders, has a legal intake line. We provide information, referrals, and support for folks. And that is the way you can reach out to GLAAD, which is open all the time, is on the website on this slide as well. So I'm going to hit pause on talking and see if anybody has any questions they would like to. Okay, you have one great question of how do we get today's slides? We are going to share the slide deck with folks who have registered after the presentation. Okay. I see someone has raised their hand, but I don't know how to answer them. Okay, here we go.
Hi, Polly. I'm wondering what your this is Annika. I'm wondering what your recommendation is for families that have traditionally chosen confirmatory adoption. So a vast majority of that is lesbian parents who are one is the genetic parent, at least one is the genetic parent and one is the gestational parent. Sometimes they're the same person. And so do you think a VAP is the best way to go, an adjudication of parentage? And if so, what's the best timing for that adjudication?
Such a great question, Annika. I will say, I'll just share my perspective and then open up for the panel, which is, I think, one of the strengths of the Massachusetts Parentage Act is it opens up options for families and really provides options that folks probably need to address with an individual lawyer, based on their particular circumstance, right? I think obviously the best practice for any family, particularly those using gamete donation, whether it's egg or sperm or embryo, is to get something that is either a judgment of parentage or a judgment equivalent, right? So I think that for folks who might not have the resources to do a confirmatory adoption, signing a voluntary acknowledgement at the hospital at the time of birth is a tremendous protection and will be very helpful. Some families still might want to do an adoption. I do think, and of course, we're working to develop hopefully forms that are as simple as possible, that the new provisions under the assisted reproductive technology provision, where you can get a judgment of parentage, I think is going to be a phenomenal tool. We have seen in other states, particularly, for example, Vermont, that is the fastest way for folks to get a judgment of parentage. And that can be done, of course, pre-birth or post-birth. So I think that the good news is there are options, and you want to do one of the options. And does anybody else want to chime in on that?
I'm going to agree completely with that. It's very exciting that we've got a lot of options because different families are going to need different things. I've definitely worked with clients who've been able to secure both of their names on a birth certificate, whether it's through gamete donation or through surrogacy, but their particular circumstances led them to need or feel that they would benefit from a post-birth judgment of parentage or even a confirmatory adoption. So people are going to need to consult with lawyers to figure out what their best options are based on their circumstances. If people are going to be moving around the country or even internationally, they might need different tools to protect their parentage.
Kath, do you want to chime in before we move on to the next
I
question?
just wanted to quickly echo what Bruce is saying. If you're moving around, I don't know how many states, and I haven't looked into this yet. Did you say something about 12 other states have
Yeah, 12
VAPs?
states have expanded VAPs, and I will say, like, under federal law, they're the equivalent of a decree. So, I mean, I
Right.
do feel, yeah, the VAP should be enough. Yeah.
Yeah. And I hope that will continue to be the case. I mean, what we've seen happen in other states has been kind of scary. So depending on people's circumstances, they should definitely be consulting with an attorney to see if something in addition to the VAP might be a consideration.
But just to clarify, we haven't seen anything scary with VAPs. What we've
Right.
seen is people who have not taken some action to protect their relationship, right? Who have, like, relied on the marital presumption, which should be enough, friends.
Right.
Should
Absolutely.
be enough. But we live in a world of discrimination, unfortunately. And again, use all your tools that you can use. I want to switch. We have a couple of questions online, and I'm going to read them both and suggest, Doug might want to take a shot at some of these. Okay. 1, de facto parentage. Will this have an effect on child support? If so, how? For example, 2 parents divorce and had a child, and mother's boyfriend becomes a de facto parent. Then they break up. Will the boyfriend have to provide support? So I think, Doug, do you want to just chime in on that?
Yeah. So if a person is adjudicated a de facto parent, they are a legal parent with all of the rights and responsibilities that go along with that. And so if someone is a de facto parent, they also have an obligation to support the child. Now, that being said, it's probably important to point out that a person cannot bring a de facto parent action against someone seeking to adjudicate them a parent to seek child support. The de facto parent action can only be done by the person seeking de facto parent status. And so if that person is voluntarily then seeking the status as a legal parent, then they are a legal parent with all of the rights and responsibilities that go along with that.
Thanks. And I'll just add in that, of course, as Doug walked through, the status is, it's an involved status with a number of standards to prove. But yes, for those who do meet the hurdles, they would be a full legal parent. All right, we've got another de facto parent question. How would de facto parenting be handled if a step parent is involved and the biological parent is not involved and has not been involved for a number of years? Doug, can I pass it to you again?
Yeah, so there are many cases in which a step parent is a parent to the child. And the step parent holds the child out as their child. The child views the step parent as their parent. And in those cases, a step parent, provided they can satisfy all 7 of those requirements by clear and convincing evidence, could be adjudicated a de facto parent. In terms of consent of a biological parent who has not been involved in a number of years, that sounds to me, assuming that biological parent is a legal parent, it sounds to me like a case that would be relevant for the impliedly consent provision. Because if the person has not been parenting the child, hasn't been making decisions, hasn't provided support for 2 years, then that person could be deemed to have consented to the step parent being a parent of the child.
Thanks so much, Doug. All right, I'm going to give a few more minutes to see if any other questions pop up or see if any panelists have any comments they want to share or pieces that they missed from their talk before we head out. All right, there's a question that came in. Okay. So someone has asked essentially, what happens if there's 2 really involved, and I'm just going to use the term legal parent, right? Because it's a great, it's a good point to remember that if you're a biological parent, you might not be a legal parent, right? Because in fact, biology alone is oftentimes not enough. You need to take more action in order to be established a legal parent. But let's say, for the sake of discussion, I think the question is, you have 2 involved legal parents, and then a step parent files a de facto parent claim. What that situation, Doug?
So under the statute, that would require that each of those parents consented to the de facto parent developing a parent-child relationship. And that has to be shown by the relevant requirements in the statute, which say that they were holding the person out as a parent of the child and engaged in shared decision-making. So that's a very high standard. We're not going to see a lot of people satisfying that. We might think that it shouldn't be that high a standard, but that's what it is. And so in those situations, you'd really have to show that there has been both of the legal parents have gotten on board with this person being a parent of the child.
Thanks so much. And we had another question that came in essentially saying, you know, what happens if one of the parents is really kind of refusing to let the other legal parent engage and is really kind of creating a barrier to that parent engaging. And before I pass it off to Doug, I'm just going to share that I think, again, the standard is, and Doug can speak to this as well, that kind of meaningful engagement really is, I think, very much gives opportunity for parents, even in that difficult situation, to show meaningful engagement, right? It includes financial support, right? It includes, you know, I've experienced parents who've been cut off from their children who have, you know, sent packages, you know, done everything in their own power to be engaged with a child. So I think that obviously the court will probably assess on a case-by-case basis kind of the particular facts of that situation. But the statute wasn't kind of intended to try to address that. Does anybody want to add to that?
Yeah, so I mean, let me just say at the outset that having reviewed all of the electronically available cases around the country, these scenarios are exceedingly rare. But they are provided for in the Massachusetts Parentage Act. And so the provisions provide that if the person has attempted to meaningfully engage with the child by requesting contact, let's say parenting time or shared decision-making, but was prevented from doing so by another person, then that could be a good cause exception to the implied consent. I anticipate that being truly a good cause exception very rarely, because it's not a common scenario that we see, but that safeguard is provided in the statute.
Thanks so much. Okay, well, I am so grateful for everyone for showing up, for, you know, learning about this new act. Please come to another session, December 9th, MCLE. Might have a slightly different panel, but we'll be going in more depth on some of these provisions. And please feel free to reach out with any other questions. Thank you, and have a great rest of your day.